So this afternoon we're going to start off with Paul Duller. Paul, you weren't in the room at the beginning of this session, I don't think, when I thanked Tribal for sponsoring the event, so I'll say that again with you in the room. Paul is an IM consultancy director for Tribal Group. He's a chartered scientist and an award-winning international records manager with over 30 years' experience of managing, developing and auditing large-scale record management projects, policies, systems and strategies. I've known Paul for a very long time through the Information Record Management Society. And it's, I think, quite a challenging question that he's going to, and paper he's going to give around student data. So actually flipping it around and giving you some ideas of what you lot might end up receiving as subject access requests. So Paul is going to give a talk on student data and GDPR. What are their rights?
Well, thank you, David. Luckily, I'm not colourblind, but I will keep pressing the green button, hopefully. So, student data and GDPR, what are their rights? Well, I have to say just one slide about Tribal. For those of you that aren't aware of who we are and what we do, we're a provider of services and technology to the education sector. There are about 1,100 of us in the company, and many of our customers rely on us to manage, to host and process their staff and their student data. So as such, data protection is absolutely the heart of everything we do. We're committed to ensuring that our systems, our services and our staff comply with GDPR and hopefully our clients too. I'm delighted to be the sponsor of today's conference. I think Dave caught me on a good day. Perhaps I had one or two more pints than I'd normally have. And we all thought it was a great idea. And then he suggested, could I sponsor it as well? So I'm delighted to. So thank you, Dave. Thank you. So what I want to do is give you a quick overview about this topic. I'm going to talk very briefly about the principles. I'm going to look in a little bit more detail about student rights and say a little bit about the guide for students that we're putting together. I have to put a caveat in a line in the sand and say this is work in progress. We're looking to produce a small student guide to GDPR early in January next year. So this is the first draft and it's hot off the press as of about 1 a.m. this morning. So thank you. So I think we're all quite familiar with the fact that GDPR is the biggest change to data protection laws in the last 20 years. It's the biggest change I'll see in my working life. And with the fines up to 20 million euros or 4% of global turnover, there's a big carrot out there to do something about it. As Dave said, there are dragons out there as well, so beware of the dragon. But yes, it's still the biggest lever you will have to persuade your board, your management, your executive team to actually do something and start to engage now. Hopefully they already have. What I see though is most activity at the moment is compliance-led. And what I mean by that is all the discussions are focused on what you and your team need to do to be compliant, but not necessarily what your students need to know. So yes, people are talking about the time frame, the effects of personal data, the fines, getting the data protection officer in place, looking at the risks, where do we start, the review, the audit, the report, planning for the provision of resources and time. There's lots of things that are happening, but what I wanted to do is give you a paper that presented a slightly more student-centric view of GDPR. And this paper will form the basis of a very student-friendly pocketbook on GDPR that we'll make available to you in January 2018. You may or may not make it available to your students, but at least you know what's coming. So, in terms of the principles, I mean, we all know that 25th of May is a day etched in everyone's calendar. It's also the day that the IRMS are having their, that week of the RMS conference in Brighton. So we'll all be celebrating or perhaps commiserating, I'm not sure which. GDPR is a replacement, and so this is absolutely key. It is a replacement of the UK Data Protection Act. It affects any EU-based organisation that's processing personal data. It also affects any organisation processing personal data or trading with individuals within the EU. So if you're processing data from students in Australia, in the UK, GDPR applies to you even though they're from Australia. okay? And we have to think about that, of course. What's personal data? Well, I think everyone, there is a clear definition in Article 4 of the GDPR about what personal data is. Basically, it's any data relating to a living individual who is or can be identified directly or even indirectly from the data. The GDPR applies to both automated personal data and now to manual filing systems as well. So we can't forget about it because they're all in 10,000 boxes in Iron Mountain. It applies now as well. Personal data that's been pseudonymized are actually within scope of GDPR. So if you have a subject access request, even though you've pseudonymized the data, you will have to provide it. However, anonymized data is not. So anonymized is good, pseudonymized, not so good. Personal data relating to criminal convictions and offences are not covered by GDPR, Article 10. They're covered by other legislation. So again, you just need to be aware of that. What is processing? Well, people say, well, I don't process, I just store it. Well, no. Collecting, storage, use, transfer, retention and destruction are all acts of processing. And GDPR applies to both electronic personal data processing and to those manual filing systems. Where's my data processed? Well, it doesn't actually matter where the actual data processing takes place within the European Union or not, as long as natural persons in the Union are being processed. Now, this is really important because in the past, internet giants like Google, Amazon, etc., have all been able to escape European privacy laws as they said, well, we're headquartered in Silicon Valley. This Data Protection Act doesn't apply to us. Now GDPR will apply to them as soon as they process personal data of any European resident. So in terms of the principles, a key objective of GDPR was to protect and strengthen the rights of the data subjects. So this is fundamentally what it's all about. It's not about us being compliant, it's actually making sure that we protect and strengthen the rights of the data subjects, and we shouldn't forget that. In general, GDPR builds on the existing data protection principles, but it adds tighter obligations and more restrictions on businesses and organisations. GDPR does not have the principles relating to individual rights or the overseas transfer of personal data. These are addressed in separate sections of the legislation itself. And GDPR features new accountability and documentation duties. So it's not sufficient simply to be able to say, well, we're compliant. We have to be able to demonstrate that compliance. We have to be able to show the audit trail, the evidence base for that compliance. You may or may not be familiar with the principles in full, but there are 6 principles, and you should be able to cite these. They should roll off your tongue as easily as anything that you cover. The first principle is that processes should be undertaken lawfully, fairly, and in a transparent manner. Information should be collected for specified, explicit, and legitimate purposes. It should be adequate, relevant, and limited just to what is necessary. It should be accurate and, where necessary, kept up to date. It should be retained in an identifiable form for no longer than is necessary. And it should be processed in an appropriate manner to maintain security. So they're the absolute underpinning principles of GDPR. So Article 5.1. Article 5.2 adds an additional principle, overarching coverage, which is the principle of accountability. So not only do we have to be compliant, but we have to be able to demonstrate and document how we are accountable. In terms of the lawfulness of processing, Articles 6 and 7, all data processing must have a lawful basis to be legal under GDPR. So for us, the majority of personal data processing undertaken by universities and colleges is carried out under a contract between the student and the establishment, not by consent. And that's quite important in terms of our lawful basis. If we are reliant on consent in any shape or form to process data, the student will generally have stronger rights, particularly if they want to have their data deleted, than if any other lawful basis had been applied. And if we are requesting consent, consent must be given the request must be given in an intelligible and easily accessible form using very clear and plain language, together and provided together along with the purpose for data processing. A key point about consent, it must be freely given, it must be specific, it must be informed and unambiguous. It must involve some form of positive opt-in, and it can't be inferred from silence, from pre-tick boxes, or simply from inactivity. That's unacceptable. In terms of identifying data subjects, again, I won't go through the articles and the recitals in detail, but the GDPR explicitly enables controllers to require data subjects to provide proof of their identity before giving effect to their rights and effectively handing over their information. So they have to provide proof of their identity. And if there are reasonable doubts regarding the identity of a data subject, the controller, you, may request the provision of additional information to confirm the identity of the data subject, but you're not required to. So it's optional. It's advisable that you do. In terms of time limits, well, you will have less time to comply with a subject access request under GDPR. Under the Data Protection Act, you had 40 days. Under GDPR, we have 1 month. Very good. Information must be provided without delay. So we don't have to wait till the end of the month if we have it. And at the latest, within 1 month of receipt of that subject access request. If you fail to meet this deadline, the data subject may complain to the Information Commissioner and may seek a judicial remedy. There are some get-outs. If you receive a large number of requests or an especially complex request or requests, the time limit may be expended by a maximum of 2 further months. But you've got to justify that. You've got to have that audit trail. And if that is the case, you've got to inform the individual data subject within 1 month of the receipt of his request and explain why the extension is necessary. In terms of fees, well, yes. The rights of access, rectification, erasure, and the right to object must all be provided free of charge. There are some caveats again. You, as a controller, can charge a reasonable fee if the request is repetitive, if it's manifestly unfounded or excessive, or if people are asking for further copies of their information. I think it's important to recognise, though, that the fact that the fee is now negated, it's free of charge, it could have a significant effect on your organisation, and certainly those organisations that receive large numbers of subject access requests. And it certainly could see an increase in your administrative costs going through the roof. At present, though, there's insufficient guidance on what is meant by manifestly unfounded or excessive, so just be careful how you approach this. Be cautious, be careful. So in terms of the student rights, well, everyone is entitled, every student is entitled, they have a right to basic information. They have a right to access information. They have a right to have it rectified. They have a right to erasure. They have a right to restrict processing. They have a right to data portability. They have a right to object. They have rights related to automated decision-making and profiling. They have a right to breach notification. They have a right to lodge a complaint. And perhaps last but not necessarily least, they have a right to compensation as well. Let's go and have a look at these in a little bit more detail. So the right to basic information. Well, under GDPR, data subjects, the students, have a right to confirm as to whether their personal information is being processed, and then to receive a minimum set of information regarding the process of that processing. So this includes, as we've seen in a few earlier slides, the identity of the controller, the reasons for processing their personal data, and a range of other relevant necessary information to ensure the fair and transparent processing. And typically this is documented in a privacy notice or a series of privacy notices. A typical contents, I think everyone's today is bringing out their own, what makes up a privacy notice. But looking through the literature, looking through the legislation, the contents of a typical privacy notice are quite extensive, which is counter to the fact that information must be provided in a concise, transparent, intelligent and easily accessible form using a clear and plain language. So it's also very clear that the information given to the data subject shouldn't simply consist of a series of giant privacy policies that are excessively long or difficult to understand. So it is about crystal clear, plain and simple language. There's a lot of information to provide and convey over to them. So again, the focus on sorting out privacy notices is absolutely paramount. I like JISC's approach to the layered model that they're using as well, so to be commended. In terms of right of access, data subjects are also entitled to access the following information: the reasons why their data is being processed, a description of the personal data concerning them, details of who has received or will receive their personal data, and details of the origin of the data if that data wasn't collected directly from them. In terms of right of access again, if a student wishes to exercise their subject access right and receive a copy of their personal data, they need to issue a subject access request, or SAR, and that has to be issued in writing, physically or electronically. This request, this is an important point, this request does not have to include the words subject access or even refer to GDPR for it to constitute a subject access request. Okay? Really quite important. Subject access requests may be made electronically, and if they are made electronically, the information provided in return should also be provided in a commonly used electronic format unless otherwise requested. In terms of rectification, well, data subjects are entitled to have their data rectified if it's inaccurate or incomplete. If the data in question has been disclosed to third parties, you must inform the third party of the rectification and also the data subject about the third parties that are involved in their data as well. And the controller must respond to a request for rectification within a month. Again, this can be extended by 2 months if the request is complicated, complex. You could always decide to take no action. So, you know, I'd like to have my degree award upgraded from a 2-2 to a first class. Well, it won't happen. So it wasn't incorrect. You can ask for it to be corrected. It wasn't incorrect. It was correct. So you can decide to take no further action. But you still have to explain why and inform the data subject of their right to complain to the supervisory authority, the information commissioner in this instance, if they're upset, if they disagree. In terms of the right to erasure, well, this is otherwise known as the right to be forgotten. And this right entitles the data subject to require an organisation that holds this information to delete the data, cease further distribution of the data, and have third parties hold processing of the data where the retention is not GDPR compliant. Key point, where the retention is not compliant. If you are compliant, this right is not an absolute right. It's quite often misunderstood, but in most cases, provided that an organisation has and maintains a lawful basis for processing the data, it will not be significantly affected by the right to be forgotten. 5, the right to restrict processing. Well, under the DPA, individuals have a right to block or suppress processing of personal data, and this restriction of processing under GDPR is very similar. When processing is restricted, they can request it, you can restrict it, you're permitted to store the personal data but not process it any further. No other processing activity other than storage. you basically can retain enough information about the individual to ensure that the restriction is respected in future. In terms of the right to restrict processing, well, under DPA, individuals have a right to block or suppress the processing of their personal data. And again, this restriction of processing is simply, we've done that one, haven't we? Yes. I've lost place. Right. Okay. Let's go on. Right to data portability. I lost my place there a second. The right to data portability allows individuals to obtain and reuse a digital copy of their personal data in a safe and secure manner. Data covered by portability requests includes personal data that the data subject has provided, as well as any observed data, i.e. anything observed or measured about the data subject, such as marks or grades, attendance records. In terms of data portability, there is data that is excluded, and that's derived data. This could be data calculated using other values, for example, ranking data, and inferred data, i.e. data created using predictive analytics, such as student risk or intervention records. 7, the right to object to processing. Data subjects have a right to object to the processing of their personal data where the basis for processing is either a public interest or the legitimate interests of the controller. This really doesn't apply to most colleges and universities. But if it does, the burden of proof is now with the controller, who has to cease processing unless it can demonstrate compelling legitimate grounds for the processing which override the interests, the rights and the freedoms of the data subject, or they require the data in order to defend their legal rights. So, as I say, this is unlikely to impact universities or colleges, as you require and rely upon a different legal basis for processing. In terms of automated decision making, well, data subjects have a right not to be subjected to a decision based solely on automated processing of their personal data, which significantly impacts them. And this does include profiling, without human intervention. So processing is permitted where you're entering or performing a contract with the data subject, providing that appropriate safeguards are in place, or it's authorised by law, or you have explicit consent for this processing. In terms of the right to breach notification, well, breach notifications to the Information Commissioner are mandatory where there is likely to result in a high risk to the rights and freedoms of the individuals. As Dave said earlier, notification must occur within 72 hours of a breach. And data processors also have a requirement to notify their customers, the data controller, without undue delay in any breach. So if you're in a chain of people and you've subcontracted it out, if they have a breach and they take 72 hours to notify you, you have very, very little time in which to do anything and notify the Information Commissioner. If a breach is likely to result in a high risk to the rights and freedoms, those concerns that the individual data subject must be notified directly without undue delay, that's as soon as possible, and be provided with specific information about the steps they need to take to protect themselves. So if you had inadvertently released their banking details, they would need to know sooner rather than later in order to do something about it. Right 10, the right to lodge a complaint. Any data subject has a right to lodge a complaint with a supervisory authority if they consider that the processing of personal data infringes, that the processing of the personal data relating to him or her infringes the GDPR. So they can complain. Upon investigation, the supervisory authority, the ICO, shall inform the complainant on the progress and outcome of the complaint. And if the data subject isn't happy with it, he has a right to an effective judicial remedy where the supervisory authority doesn't handle the complaint or, in his mind correctly, or doesn't inform the data subject within 3 months on the progress or outcome of the complaint. Right to compensation. Well, last but not least, okay, any data subject has the right to compensation for a material or non-material damage resulting from a GDPR infringement. So they can claim. Again, we're waiting for further guidance on how big and how that could be. And that compensation could come from both the controller and the processor as well. So to wrap this up, there are a few key takeaways I'll give you. Fees. In most cases, the GDPR doesn't permit fees to be charged. There's a risk that individuals actually are going to attempt to exercise their rights merely because they can, and it doesn't cost them anything. And it could be a cheap but very effective means of protest, certainly in some of the universities we're covering. This could result in an increase in administrative costs. And I think the key point to recognise as well is there is no limit placed on the cost of completing a subject access request. Now that's been challenged recently in the High Court by Oxford University, but who imposed a cap of at around about £120,000 for one subject access request. They'd spend that much. So be careful. In terms of mandatory information, GDPR expands the mandatory categories of information which must be supplied in connection with a subject access request. A lot of the information you need to put into your data privacy impact assessments and collect there is also part of your privacy notices. So such requests will put, again, a greater burden on your data protection officers than you've currently experienced. Time limits, well, again, from 40 days to a month, it's a more onerous compliance regime. And subject access requests, well, again, just bear in mind that they don't need to include the word subject access or even GDPR. And just because it ends up sitting in the wrong in tray, it doesn't make it less valid. It's therefore essential that all staff can recognise a subject access request and know exactly who to pass it on to. All of this information is being summarised and collated as part of a little project I have on the go in terms of putting together a student pocketbook, a little student data know your rights. It's going to be a free pocketbook distributed to our clients and friends based upon this presentation early in January 2018. If you'd like to obtain a copy of the pocketbook and today's presentations, just register your interest on our stand, sign up there, or email me at paul.duller@tribalgroup.com. So I hope you found that useful. I think I'm on time, Dave. Thank you very much.